Welcome back. I am Deepan Purival and you're watching the Savera. While resolving a vexed constitutional situation in Tamil Nadu, the Supreme Court is believed to have set a 3-month deadline for presidential and gubernatorial assent to bills passed by the legislature for the second time, a decision sparking an outcry over possible judicial outreach by seeking to bring presidential actions under judicial review. A bench of Justices J.B. Pardiwala and R. Mahadevan set aside Tamil Nadu Governor R.N. Ravi's decision to withhold assent to pending 10 bills and in the process ruled that the President should also not take more than 3 months in arriving at a decision on bills referred by governors. The bench's verdict, uploaded on its website, seeks to reinterpret the constitutional scheme of things and casts a shadow on the federal relations between the centre and the states. It said that the President's functions are amendable to judicial review under Article 201 with the heading Bills Reserved for Consideration. Article 201 of Indian Constitution states that when a bill is reserved by a governor for the consideration by the President shall either give his assent to the bill or withhold his assent therefrom. The article goes on to state, provided that where the bill is not a money bill, the President may direct the governor to return the bill to the House, or as the case may be, the House of the legislature of the state together with such a message as it mentioned in the first provision of Article 200, and when a bill is so returned, the House or Houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and if it again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. While deciding the Tamil Nadu deadlock in favour of the DMK-led state government, Justices Pardiwala and Mahadevan used the court's inherent powers under Article 142 of the Constitution for the purpose of declaring the 10 withheld bills as deemed to have been assented on the date when they were presented to the governor after being reconsidered by the state legislatures on November 18, 2023. The court said that the governor kept the 10 bills pending with him for unduly long periods in violation of the principles laid down by the court in the Punjab governor's case in November 2023. He seemed to have been weighed by extraneous considerations. In doing so, the bench opined that the Supreme Court in its judgment held that it is not open for the governor to reserve a bill for the consideration of the President once, if it is presented before him in the second round after having been returned to the House previously and then repassed by the legislature. Constitutional experts and former Law Minister Kapil Sibal have hailed the verdict. Sibal said that delay in assent by governors over bills passed by state legislatures has long been used as a tool of harassment by the central government, as the governor is somebody who's appointed by the federal government itself. The Supreme Court has ended the scope for unexplained delay and set a 3-month deadline for governors to decide, he said, adding the Attorney General had opposed the decision over the setting of deadlines. But the apex court dismissed the government's contrary stand. Sibal called it a historic verdict and a boon for the federal structure of the country. Stay tuned for more updates only on Savera, and do subscribe to our channel and download the Savera app.